Well, good morning and thanks for watching this special edition of the Market Day Report with extensive coverage from the AFBF convention. I'm Janet Adkison. Thanks for joining us. Well, 2017 was another active year on the agricultural law and taxation front. And in today's extra Rural Money segment, we review the top 5 ag law developments of 2017. And joining us here on set is Professor of Ag Law and Taxation at the Washburn University School of Law, Roger McEowen. Roger, thanks for joining us once again. Such a pleasure to have you in studio.
Oh, it's nice to be here.
So we said, you know, the top 5 ag law moves over the last year. Where do you start?
Oh, yeah, that's a great question. In fact, my last week on my blog, I started out with the almost top 10 because it was tough to just get it down to 10.
Right.
And then the numbers 10 through 6, and then, of course, the top 5. But I think in the top 5, there are a couple of, there's a water development, there's a couple of environmental developments, and a couple of tax developments. Course.
Well, let's start with number 5. What do you have tapped as number 5?
Well, number 5 is the federal implied water rights doctrine. And what that is, it's a big case, and it actually came out of New Mexico, and it went on to the Ninth Circuit Court of Appeals. And this is very important because the federal government owns about 28% of the land area of the United States, with half of that concentrated in 11 states out west. So if we take Alaska out of the picture, those are the numbers. And what the Ninth Circuit, to boil it down, what the Ninth Circuit said is that the federal government has implied water rights that will supersede state water rights on federal property. And so that's a lot of the land area out west, and that includes groundwater. So when you think of groundwater in general, how important that is out west, with the federal government being able to, in essence, trump state law with respect to that, and what the states are trying to do to preserve groundwater and manage it, this being the first federal appellate court to ever decide the issue is a very important development for water rights and the future of water in the West.
Now, switching gears, give us a recap of the EPA rule exempting farms from the air release reporting.
Yeah, this is a rule that applies to confined animal operations of a certain size. Once you get up, 300 or 400 head, there's a rule that kicks in. When you have 100 pounds of certain chemicals released, generally ammonia is what we're talking about with respect to the confined facilities, then you're subject to a couple of reporting requirements, one under the Emergency Planning Community Right to Know Act, and the other one under the General Clean Air Act and Clean Water Act also. But the EPA put a rule in place that exempted ag from the Clean Water Act reporting rules, and they left intact the Emergency Planning Community Right to Know Act reporting. Well, some of the environmental groups were opposed to that, and they sued and saying, well, you can't exempt ag from the one set of the reporting rules. And long story short, it went through the courts. The courts agreed with the environmental groups, and now starting in late January of this year, there will be a reporting rule that's in place, and that's going to have an impact on some confinement operations. The University of Nebraska has estimated that a facility will reach the point at which they'll be regulated once they get to about 330 head for a confinement facility. So there's an extra reporting requirement that's going to kick in for those facilities.
Well, let's go ahead and skip ahead. What did you have number 2 on your list?
Number 2 is a tax development, and this is a big case. Many of the viewers will understand when I mentioned the Mizell case. That was a case in 1995 by the U.S. Tax Court involving an Arkansas set of facts, and it's a very common setup in agriculture across the country. And that is, you may have a farmer that owns their own land or has it in a different entity and leases their land to their farming operation. And so they're getting rental income back, and if that's a passive lease, we would say that that's not subject to self-employment tax. IRS said that it was in that case, and the tax court agreed with that. A few years later, the U.S. Court of Appeals for the Eighth Circuit, which is a lot of the Midwest, Arkansas North, pick up the Dakotas and get Nebraska, and that's the Eighth Circuit, they said there's a carve-out where your rental income will not be subject to self-employment tax if the rent represents a fair market rate of rent. The tax court in late September of 17 applied that carve-out exception to the entire country. That's absolutely huge, and there's an opinion by Judge Paris on the tax court.
Well, let's go ahead, and what is number 1? If I had a drum roll, I would use it for you here.
You could probably guess what number 1 was in 2017. It came in late in the year, and that was the tax bill. Obviously, ramifications for agriculture and all taxpayers are very large. It's a major overhaul of the tax code, the first time since 1986, and we're going to work out the details of this for many months to come.
And you know, you joined us here earlier this morning, as did Paul Neefer, and it seems like from the conversation that we had, it just seems like there's no better time to really accept the fact that you need a tax expert.
Oh, that's absolutely true. I know a lot of the discussion was, and the attempt by Congress was to simplify things, and in some respects they did. In other respects, the game has changed, and it's, at least in some instances, it's more complex, but I think in all instances, people need to be talking to their tax professionals soon.
Out of curiosity, whenever the tax law is set, is there ever any time whenever they may think, you know what, we did need to tweak something a little bit more? Does that ever come back into action?
Yeah, we could see a technical corrections bill in the next few weeks with respect to the tax bill. That's a possibility. There's also a possibility that they'll catch a couple of things that will affect farmers in the farm bill, particularly with respect to the AGI computation for determining whether a farmer is eligible for payment limits. Those are a couple of things that I would keep an eye on to see if those get corrected.
If there is a technical correction other than what they can do in the farm bill, is there maybe something that you really expect to be maybe top of that list in agriculture or not? Yeah,
I would say we talked about this earlier, the QBI deduction, the 20% deduction, how that influences sales to private elevators as opposed to cooperatives. There is some discussion as to did Congress really intend how that appears to read. Now, of course, we don't have any IRS forms, we don't have any regulations on this yet, but that's one area that I think they might take a look at.
Now, we've set up, and of course, we've been talking about the top 5 ag law related topics of 2017. We're already in 2018. Is there anything kind of teed up for you to keep your eye on this year?
There's a case coming out of South Dakota. And I checked actually just a few minutes ago, the Supreme Court issued their orders today. Today was an order day. We're watching to see whether they're going to take a case from the Supreme Court of South Dakota, which involves the issue of a state having the ability to impose state sales tax or use tax on a business that has no physical presence in the state. And when we think about that, that has a wide application potentially, if a state's able to do that, to many home-based businesses that use the web and use other types of marketing as opposed to the big box retailers. So I can see a lot of small town, rural, and farming operations that sell their products like that across state lines and in multiple states that are not subject to sales and use tax in the states where their buyers live, but would be if the Supreme Court takes this case and overturns 50 years of U.S. Supreme Court precedent. Wow. I think that's a big one, and that's we're waiting to see whether the Supreme Court's going to take the case.
All right, well, I'm sure we'll talk about that more in the future. Thank you very much for joining us. We certainly appreciate it.
Thank you.
Well, again, Professor of Ag Law and Taxation at the Washburn University School of Law, Roger McEowen, joining us here on set today for your Market Day Report.